So with all of that out of the way, I'm going to quickly introduce our speakers and turn it over to them. I'd first like to introduce Michelle Nowlin. She is clinical professor of law at Duke Law School and co-director of the Environmental Law and Policy Clinic. Steve Roady is a professor of the practice of law at Duke Law School, and we're fortunate to have him as a faculty fellow at the Nicholas Institute. And finally, Shannon Arata is an attorney with Calhoun, Bella, and Seacrest. She is also formerly a lecturing fellow at Duke Law School. So with that, I believe, Michelle, you're up first, and I will turn it over to you.
All right, thank you very much, Jeremy, and welcome everybody. So what we're going to do today is go over some of the background facts so that you will have some grounding for understanding what we're talking about here. We'll also provide some context about what an amicus brief is, because that was the role that the three of us played in filing an amicus brief on behalf of several, I guess many professors of environmental law and natural resources law throughout the United States. And then we're going to talk about what the arguments were, the significant arguments that were raised in the case, what the Supreme Court ruled in its decision last week, and then what that all means for the regulated community and for those who care about the quality of our environment moving forward. So with that, I will start off with the background situation. And Jeremy, you can advance to the next slide, please. So I want to start by just providing some context of the statutory background that will help ground the arguments and the facts of this case. So before the Clean Water Act was adopted in 1972, the only role that the federal law played really was setting ambient water quality standards. And those really required people concerned about the quality of the surface waters to work backwards to identify the source of pollution after the water was already degraded. This led to lawsuits. It created a lot of problems in trying to figure out what the source of the pollution was. And as a result, our national waters were so degraded that lawmakers, at least one lawmaker, had referred to our rivers as sewers to the sea during the debates on the Clean Water Act within Congress. So obviously a different approach was needed, and Congress came up with a novel idea to try to stop pollution at the source. And that's really what the Clean Water Act is designed to accomplish. So it goes about that through a primary goal of restoring and maintaining the physical, chemical, and biological integrity of waters of the United States. Waters of the United States is variously referred to as surface waters or navigable waters. And the structure of the Clean Water Act has a primary prohibition: no discharge of any pollutants into navigable waters without a permit. And that permit is referred to as an NPDES permit. Those initials stand for National Pollutant Discharge Elimination System. This is a regulatory permit that sets effluent limitations that are technology-based standards limiting what can be discharged and in what amounts. Those effluent limitations are then designed to facilitate the attainment of water quality standards that the various states will adopt, dictating the best uses of the rivers within their political jurisdictions. So they are basically trying to make sure that those water bodies are suitable for fishing, for swimming, for boating, and for drinking. The Act sets up a strict liability protocol, meaning that it doesn't matter whether you intended to discharge that pollutant or not. The mere fact of that discharge into navigable waters is sufficient to require—
Dave, please leave a message. I'll call you back as soon as possible.
I'm sorry, could somebody mute their mic, please? So if you violate the terms of the statute without a permit, or you exceed your permit limitations, that will subject the regulated entity to the possibility of civil penalties, and in some rare instances, maybe even criminal liability. One of the other innovations that the Clean Water Act adopted was the availability of citizen suits like the one that was used here, meaning that if the government agencies are not enforcing the statute. If they're allowing entities to pollute, if they're failing to safeguard those water quality standards, then ordinary citizens are empowered to step into the shoes of the government and enforce the terms of the statute on their own. One of the key structural distinctions that the Clean Water Act makes is between a point source and a non-point source. And this becomes a very important distinction in the court proceedings in this case and in the Supreme Court's ultimate decision. Ultimately, the Clean Water Act and all of its requirements, its operation, its implementation has been wildly successful in protecting water quality.
Internet connection is unstable.
Excuse me, can you please mute your mic? Thank you. It's been wildly successful in attaining its goals and in restoring the functionality of our nation's waters. Now, the key to understanding the arguments in this case and the way the statute actually works is the definitions of key terms. And each one of these terms, I think at the beginning I talked about how, the main point or the main prohibition in the Clean Water Act is that no point source may discharge pollutants into navigable waters without a permit. And so each one of those key terms is defined in the statute, and each one of those definitions has been the subject of significant litigation over the 50 years of the statute's implementation. So what does it mean to discharge a pollutant? It means the addition, any addition of any pollutant to navigable waters from any point source. So each of these terms, as I said, has been defined, but this is the key terminology that this particular case involves. Jeremy, you can advance to the next slide. So that then leads us to ask, well, what exactly is navigable waters? And so those navigable waters are defined as our surface waters, waters of the United States. It's somewhat circular within each one of these definitions. And then what is a point source itself? Because that's the entity that gets regulated through the NPDES permitting program. A point source is any discernible, defined, or discrete conveyance, including, but not limited to, ditches, pipes, tunnels, channels, conduits, wells, and discrete fissures. So that defines the category of entities that could be classified, but its key here is that one of those classifications has to be the source of a discharge of pollutants into the navigable waters. And so that is the statutory background and the key definitions that are at issue in this case. And Jeremy, please advance to the next slide. So that leads us to talk about the facts of this particular case. So the Maui case focuses obviously on the County of Maui and discharges from the Lahaina wastewater reclamation facility located here at the top right of your screen. For the past 40 years, that wastewater facility has been receiving sewage from the residents of the community, and then treating that effluent, the sewage from their homes, to reclamation standards, which is different from effluent discharge standards, and then injecting that treated wastewater into a series of 4 underground injection wells. It was known at the time that the facility was constructed that these wells would intermix with the groundwater, and it was assumed that that groundwater would then discharge into the waters of the Pacific Ocean off the coast of the Kahekili Beach, just offshore. And so this particular, you can go ahead, that was fine, to advance to the next slide. This demonstrates a little bit of the hydrology of the area and how the wastewater reclamation facility works. And you can go on to the next slide. This slide shows the directionality of the groundwater. And so again, you would have that Lahaina wastewater reclamation facility up now towards the top center of your screen. And the groundwater it's a very narrow lens that then circulates up and around and then discharges into the Pacific Ocean. This was done by design because it was understood that treating the effluent to a higher standard, as would be required by the Clean Water Act, would be more expensive and would require the removal of more of the biological contaminants and nutrients that were present in that waste stream. At a reclamation facility, that wastewater is treated to a certain degree, but then also can be suitable for other purposes such as land application. But in this instance, they decided to discharge it into those underground injection wells, which would then seep into groundwater and eventually into the Pacific Ocean. So this was all done with knowledge and with intent. And unfortunately, there were significant problems that started to become obvious. And over the last 2 decades, those problems became much more severe, much more visible. And that's when these environmental plaintiffs got involved to bring the lawsuit against the county and try to get them to reduce the amount of effluent that was being discharged and come into compliance with the Clean Water Act. Please go to the next slide. And so this is, I'm sorry, just a little bit of an overview of, again, how the facility works. Go on to the next slide. This slide illustrates the damage that was being caused by the effluent, pointing out that there are real consequences at stake here. On the right is what the properly functioning coral reef would look like. You would have a very healthy coral ecosystem that would support fish and other populations. And significantly, that coral reef also provides an important buffer to protect the beach and the residents of the County of Maui from storm surge and high surf. There are concerns about what the effluent is doing to the reef, as you can see by the photo on the left. There were algal blooms that smothered the coral, and as a result, there were declining fish and sea turtle populations, coral bleaching and breakdown, and scientific studies documented a 40% decline in the actual coral reef cover in a 10-year period between 1994 and 2004. So there are real consequences at stake here. Once the parties started to try to negotiate what would happen, how this would look for the county to reduce that effluent discharge or clean up the quality of the effluent, the parties agreed to conduct a study using tracer dyes that would be put into those injection wells and then see where they came out within the ocean and how much time it would take. And these tracer dye studies showed that between 60 and 90% of the effluent is actually reaching the near shore, and that the nutrient load is the problem that is causing the breakdown of the coral ecosystem. So the environmental groups then tried to negotiate with the county to reuse that effluent, clean it up in some way, but those negotiations broke down, and so the environmental group sued. They prevailed in the federal district court in California, and when the county appealed, they also defended their position before the Ninth Circuit, which also issued a ruling in 2018 in support of the environmental plaintiffs. The county then decided to seek Supreme Court review, and that's where we come today. But I want to, before handing this over to Steve to talk about the role of the amicus, is to make clear that the audience understands that this case is not taking place in a vacuum. Although this is the case that went up to the Supreme Court and which the Supreme Court ultimately ruled in, there were companion cases that were also seeking Supreme Court review that raised similar questions of whether that statute applies to indirect discharges that reach surface waters. So there was a companion case in the Fourth Circuit, Upstate Forever versus Kinder Morgan. And the Fourth Circuit in that case determined that yes, indirect discharges are covered as long as there's a hydrologic connection between the source of the discharge and the actual surface water. There was another case dealing with coal ash ponds in Kentucky, Kentucky Waterways Alliance versus the Kentucky Utilities Commission, and another case in Tennessee also dealing with coal ash ponds. And in those cases, the Sixth Circuit Court of Appeals decided that no, indirect discharges are not covered. And the Sixth Circuit also decided that groundwater itself is a non-point source of pollution that is excluded from the purview of the Clean Water Act. And so in issuing its decision, the Supreme Court articulated a standard that would then be applied in these cases as well. Steve?
Thank you, Michelle. Before Shannon gets into the details of who argued what and what the court held, we thought it would be useful just to take a brief second and give you folks a kind of a bird's eye view of the larger battlefield that this case was fought out upon. As Michelle mentioned, none of these cases arise in a vacuum, and literally in this country, since the 1970s, so over 40 years now, there's been just a really, really strong effort by industry to push back against a series of seminal environmental statutes that were enacted back in the 70s to protect our environment. They started with the Clean Air Act in 1970 and then the Clean Water Act in 1972. And there's been a series of skirmishes and battles in the courts ever since as these acts have been implemented. And industry, in general terms, has fought against restrictions that flow from these acts. This case is no exception. And so when you get a case of this significance where what's in play is the very heart of the act, the very heart of the permanent requirement that seeks to limit pollution from point sources, these cases become very significant. And the Supreme Court rarely takes an environmental case like this. It's unusual because the court has discretion whether to grant review or not. The net result of all that is that by the time a case actually ends up in the Supreme Court, where the very essence of one of these pollution statutes is in play, you have a whole array of folks who want to get involved, and they come in as so-called friends of the court, amicus briefs get filed on behalf of all these parties. So in this case, for example, there were something like 19 or 20 friend of the court briefs filed on behalf of the County of Maui, filed by industry groups, Chamber of Commerce, energy companies, those kinds of entities, and by a bunch of states who wanted to arrogate the ability to regulate groundwater to themselves and claimed that the Ninth Circuit ruling was a problem for them. On the other side, you had probably a dozen amicus briefs filed on behalf of another set of people who felt that the Clean Water Act was really important and the non-point source pollution argument should not be allowed to dilute the requirement that there shouldn't be any pollutants discharged in inhabitable waters from point sources. And on that side of the fence, you had maybe a dozen states. You had a brief on behalf of 37 law professors that Shannon and Michelle and I wrote and filed. And by the way, we're delighted. I want to welcome, we have a few of those amici law professors, I think, sitting in on the meeting today. And there were also a series of other amici briefs. We have, I think, an author of one of those briefs on behalf of former EPA officials also on the call today. So there were a number of amici on each side of this battlefield, all contesting for the court's attention. What we tried to do in our brief was to say, a lot of people have spent a lot of time with this act over the years, law professors. Some of them helped write the original act. Some of them wrote the definitive histories of the act and its implementation. And they can help the court understand the design and purposes of the act. And we wanted to be able to reassure the court that staying with the reading of the plain language and purposes and legislative history of the act was the proper way to go and was fully justified. And that was the intention that we brought to this exercise. So with that as an intro for Shannon, I'll let Shannon take over and talk about a little more about the details of how the case then unfolded in the Supreme Court.
Thank you, Steve, and thank you to everyone who's joining us this morning. I'm going to try to give a very quick overview of what the parties' main arguments were and then what we argued on behalf of the respondent nonprofit organizations. So the key argument really boiled down to Section 301 of the Clean Water Act, which prohibits the discharge of any pollutant by any person into navigable waters. And as Michelle indicated, the way that key provision was argued was by looking at the Clean Water Act's definitions, which are provided in Section 502, and in particular, the definition of discharge of a pollutant, which means any addition of any pollutant to navigable waters from any point source. And it might seem silly, but the opinion and the arguments really focused on that last from in that phrase. And before I move on, I just want to make sure that everyone is aware, because we might lapse between terms, that the term navigable waters refers to waters of the United States or bliss. I assume if you're joining us this morning, you probably already know that, but I just want to be safe. So the petitioner in this case was the County of Maui. The county had lost its appeal before the Ninth Circuit petitions for the Supreme Court to hear the case. And there's really a spectrum of arguments in their extremes. One extreme would allow almost no regulation of discharges, and the other extreme will allow the overregulation of even minute discharges could potentially require NPDES Clean Water Act permits. The County of Maui's argument was not all the way at that one extreme of requiring almost no regulation, but it was pretty close. The county interpreted the Clean Water Act's language very strictly and developed an argument that was, as I said, much closer to one far end of the spectrum. And they did that by defining from using multiple different terms. They said that from could mean a starting point, a means, an instrumentality. And they concluded that from is not actually ambiguous and quote, like a chameleon, and that we have to draw its meaning from the context of the Clean Water Act rather than from its plain language. In other words, the county concluded that from refers both to the beginning, middle, and end of the transport process in navigable waters, and that the only possible next stop for that effluent can be a navigable water. That is, there's no intervening media, soil, air, groundwater, anything that comes between that last molecule of the point source and the first molecule of a navigable water disrupts the chain. That means no regulation. It's a non-point source discharge, therefore no NPDES Clean Water Act permit. The County of Maui referred to this as the means of delivery test. And what they said was that without this test, permitting agencies permits from even the minute sources, and residential septic systems were brought up quite a bit during arguments. They also mentioned non-navigable water to the states to regulate, and by allowing groundwater to serve as a transport instrumentality for polluted effluent, that would upset states' rights. And Congress did not intend to do that. The respondents in this case, on the other hand, the respondents were the Hawaii Wildlife Fund, Sierra Club, Maui Group, Surfrider Foundation, and West Conservation Association. Interpreted the word from differently, and their interpretation was more towards the middle of the spectrum, closer to the end that would have allowed for overregulation. But what the respondents did quite well, we thought, was come up with a test that would, like common sense, and allow for those minute discharges to not fall under the purview of the NPDES permitting program. The respondents pointed out that from means a function word to indicate a starting point. And I should also mention that I think pretty much every brief cited directly to dictionary definitions. That's what this case came down to. And based on the respondents' interpretation and understanding of what the word from means, they came up with a traceability and foreseeability test that's supported by the Clean Water Act structure and history. Traceability, or fairly traceable, means that a person must establish factual causation. Foreseeability means that a person must establish proximate causation, and proximate causation means that a pollution of a navigable water was a natural consequence of a release from a source. What this does is allow for intermediate means of transmission, like groundwater, soil, air, to not prevent the Clean Water Act regulation so long as it was traceable and foreseeable that a navigable water would be polluted. And as Steve mentioned, Steve, Michelle, and I had the pleasure of drafting an amicus brief on behalf of 37 law professors in support of those nonprofit respondents. It was not a scientific brief. A lot of amicus briefs are. Information not otherwise. This was a legal analysis brief, and perhaps unlike the parties to the case, the law professors who joined our brief had extensive, meaning decades worth of experience writing about the Clean Water Act's organization. Some had experience with drafting the Clean Water Act statutory language and testifying as to its meaning. And so we thought they brought a valuable point of view that the court should consider. Our brief started pretty simply with the Clean Water Act's plain language. We agreed with the respondents. We cited, luckily, to Justice Kavanaugh's Harvard Law Review book review on fixing statutory interpretation, and that in which he explains that understanding the plain language of a statute means reading the words, quote, how the words would be read by an ordinary user of the English language. We also pointed to the Clean Water Act's context and structure and its legislative history, all of which supported our conclusion that the desire to point source pollution to the states did not mean that it intended to leave a gaping hole in the statute that would allow polluters to do indirectly what the act directly prohibits. That's degrading the waters of the United States with impunity. We also lucked out because we weren't alone in this interpretation. The late Justice Scalia actually agreed with us. In writing the opinion in the famous Rapanos case, Justice Scalia scoffed at the idea that the act would allow discharges to pollute waters not covered by the act as a means of polluting covered waters. And we felt that that was an effective argument. I think it probably was, because as we'll talk about a little bit, Justice Scalia's words were reflected in Justice Kavanaugh's concurrence with the majority opinion in this case. And before I talk a little bit about what the Supreme Court opinion actually said, I'd also like to point out the number of amicus briefs that were submitted in this case. It goes to show the amount of interest and the importance. On behalf of the County of Maui, on behalf of the petitioner, there were 18 amicus briefs filed from a wide range of organizations and individuals, including the U.S. Chamber of Commerce, the National Conference of State Legislatures, and Kinder Morgan Energy Partners, which, as Michelle had mentioned, had been involved with a similar Fourth Circuit case that was decided on a slightly different reasoning. On behalf of the respondent nonprofit organizations, there were 10 amicus briefs, including the Constitutional Accountability Center, former EPA administrators and officials, and the Upstate Forever and Savannah Riverkeeper. The last one of those groups, or those two groups, also had participated at the Fourth Circuit. I'll turn it back over to Michelle to talk about what a couple of weeks ago opinion actually means.
Thank you, Shannon. So last week, the Supreme Court issued this much anticipated decision, and it was, I think, what we would interpret a resounding victory for upholding the principles and goals of the Clean Water Act and the role of the Clean Water Act in protecting the aquatic health of our ecosystems. This was a 6-3 decision, and the majority opinion was written by Justice Breyer, and he was joined by Chief Justice Roberts and Justices Ginsburg, Kagan, and Sotomayor. There was a separate Justice Kavanaugh also joined that majority decision. He also wrote a concurring opinion to explain a slightly different basis or an amplified basis for his agreement with the majority's decision. There were dissenting opinions filed also. Justice Thomas was joined by Justice Gorsuch in a dissent, and Justice Alito wrote his own separate defense. So I'm going to go over just very briefly the majority ruling, and if time allows, I will touch on the arguments that the dissent raised. So in the majority decision, the ultimate holding was that if the discharge is the functional equivalent of a direct discharge from a point source into navigable waters, then the Clean Water Act will apply and an NPDES permit will be required. The oral argument for this case, as well as the decision itself, were really fascinating, and something that I think would make any linguist or a grammarian blush with "I told you so" pride, because it really focuses on the plain meaning of ordinary words, the function and definitions of prepositions, how a sentence is structured, but it also underscores the basic principles of statutory construction and looking to the policies that innervate a statute and not to individual segments of that statute in isolation. As Shannon said, one of the key arguments in the case at oral argument and in the briefs was, what does it mean to be from a point source? Is that directly from a point source? Is it indirectly from a point source? And if it's indirect, over what conditions might that be? Does any medium break that causal chain? Does time or distance break that causal chain? And in reaching its decision, the court articulated what it determined to be its definition of from, and then also looked to the ordinary meaning of that word, how it's used, and the context of the statute and its objectives. The court wrestled with the question of that intermediary medium through which a pollutant might pass before reaching navigable waters. And it was concerned with the evasion of the strict requirements of the statute that would end up defeating the statute's central purpose of restoring, protecting, and maintaining the health of the nation's waters. And so it really, as Shannon alluded to, struggled with the spectrum of arguments, and each argument it took to its logical extreme. So when rejecting the argument that was posited by the county and its associated interests, the court said that those focus exclusively on the means of conveyance and represented an attempt to read an absent word into the statute, and that absent word is direct. By the court's reasoning, going to a logical extreme there, if the effluent touches an intermediating medium before reaching surface waters, then that causal chain would be completely severed and there would be no liability. It's kind of like the last touch on the ball in soccer, if you will. It also, though, rejected what it perceived to be the logical extreme of the environmental groups and their associated interests argument. Those groups relied on the structure and context, as well as the background principles of tort law in terms of proximate cause, to achieve the statute's directives and goals. If the pollutant originated at a point source, then the discharge requires a permit. And the illogical extreme of that the court was worried about was that it would require a permit no matter how far, or over what period of time, or through what type of medium, or even in what amount that pollutant ultimately reached the waters. We don't need that slide. And so in imagining that Pandora's box of horrors with the extreme on both sides, this large and obvious loophole that would facilitate evasion of the law versus something that was far too tenuous to support liability, one of the things that the court was questioning was, what if it happens over the period of 250 years or over the course of 100 miles? What if that drop of effluent was carried on the wings of a butterfly? Those were the types of extremes that it spun out and was concerned about. And so in its decision in finding this functional equivalency argument or test, the court was really seeking to forge a middle ground, that golden mean that would uphold the ordinary meaning of the language, the strict statutory definitions, and the ultimate policies that were behind the statute itself. So in articulating its holding that a discharge that is the functional equivalent of a direct discharge would require a permit, what does functional equivalence actually mean? And while the court majority did not offer a clear, succinct opinion or definition of that term, it did posit 7 different criteria that were not exclusive that would, in its view, sufficiently guide the agency in developing clear regulations for the regulated community and for future courts that would be asked to interpret its ruling and apply its ruling to different cases that arise. But one of the things that the court suggested here is that the impact also really matters, not just the origin of the pollutant, not just the route that it took in reaching those navigable waters, but also the impact that it has. And so pollutants that would reach the waters of the United States in de minimis amounts would not trigger the NPDES permitting requirements. So in conclusion, the court wrote that in light of the statute's language, structure, and purposes, the interpretations offered by the parties, the government, and the dissents are too extreme, and adopted this test of functional equivalency of a direct discharge. Justice Kavanaugh wrote a concurring opinion that really relied on and found dispositive Justice Scalia's interpretation of the word from in the Rapanis case, and articulated or restated those concerns about evading the law if the county's arguments were to have prevailed. He also acknowledged that the statute does not provide a bright line test, and so that what the court had tried to do in its majority decision was translate the vagueness of the word from into concrete guidance through the articulation of these 7 different standards. And then in his final point, he emphatically disagreed with Justice Thomas's dissent and defended the articulation of those factors to guide the agency and the courts and the regulated community in the future. The dissents, Thomas and Gorsuch, also purported to focus on structure and context, but in their conclusion, they decided that the word from was not the pivotal definition to focus on, but the word addition. Did the addition of pollutants actually augment those surface waters, and did it do so naturally or by mechanical means? And through that reasoning, that Thomas and Gorsuch would have limited the purview of the act to direct discharges themselves. They foresee significant practical problems with implementation, which were also among the justifications for their dissenting opinion. Justice Alito also wrote a separate dissent. And one of the things that he seems most concerned about is, number one, that even though the regulators knew that the facility had been designed to allow discharging of effluent into surface waters, they had done nothing to prevent this or to bring the wastewater treatment facility into compliance with the Clean Water Act over a period of 40 years. He also seems very concerned about the administrative nightmare. He imagines an administrative nightmare in applying this ruling to the more than 6,600 underground injection wells in Hawaii alone, much less, the rest of the 49 states. And he also, I think, makes an error in conflating groundwater with non-point sources of pollution. And this was an argument that was put forth by the county, and I think is a misreading of the Clean Water Act itself. Another interesting aspect of Alito's dissent was the apparent disregard that he holds for citizen suits. He wrote that the availability of citizen suits exacerbates the danger of this decision to ordinary landowners. So in sum, both the majority and the dissents focus on the definition of key words, but it's only the majority that uses those definitions within the context of the animating purposes of the statute and the goals to protect aquatic ecosystem health across the country. So that does it for our overview of what the court decided, and I'll now turn it over to Steve to talk about what this actually means moving forward.
Thank you, Michelle. So here we are, we have this opinion, what does it really mean? And I think we have a few thoughts on what it means, although frankly, we're still reading and rereading the opinion. It's a fascinating opinion by Justice Breyer, and we're all obviously very pleased with the outcome. So I think a couple of things to say before we jump into questions. The first thing to say is the Clean Water Act has survived intact and is vibrant. The overall purpose of the act to protect surface waters of the U.S. from discharge of pollutants remains fully operational. The loophole sought by the county and the industries was not agreed to by the court. And, you know, I think it's safe to say that the court was persuaded by the briefs that were filed by everyone that, in fact, you know, the central purpose of the act really was important. In fact, if you read Justice Breyer's opinion, you'll see that he adverts to the purposes of the act multiple times throughout his opinion. And it really animates his discussion of the pros and cons of the various arguments, as Michelle said, at the extremes. He continually goes back to the lodestar of we need to protect navigable waters from discharge of pollutants, and that seems to guide his analysis. One of the chief arguments that was made by the County of Maui and their amici was that when Congress decided not to specifically regulate groundwater, somehow that cut against the overall purpose of the act to protect surface waters from pollution. And, you know, Justice Breyer specifically says, you know, that's a pretty indirect argument. If you're going to make that kind of argument that somehow because they decided much later in the process to go ahead and let the states take the lead on groundwater, that somehow takes away from the overarching purpose of the statute, seems awfully indirect to me. We actually had made the argument in our amicus brief that that would be akin to hiding elephants in mouse holes, which is a phrase used in an earlier Supreme Court case where the court said, you know, if you've got a basic statutory purpose, you can't look deep in the back of the statute and find some sort of reference and somehow use that to undermine the statutory purpose. And clearly, Justice Breyer was not into allowing elephants to be stuffed into mouse holes and let this, you know, provision be siphoned off by the arguments that the petitioners were making. The other thing I would say is that, and I think one of the benefits of this opinion is that the court was at some pains to knock down some of the usual arguments that people who've been fighting against the reach of the act have made for years. And they've always said, it's way too onerous, it's too burdensome, it's, you know, it can't be fine-tuned. They slapped that down and said, no, the administrator has done a good job over the years of regulating, and they can do things like general permits and they can do other things. And so they specifically blessed that approach and thereby knocked out one of the big arguments that's been made over the years. And the other thing the court said was, and don't talk to us about the onerousness of these penalties because district court judges can do equity in these cases and they can balance the factors in any particular case, looking at some of our factors like time and distance and, you know, foreseeability as it were. And so, and then I have to say that particular passage sounds a lot to me like a Chief Justice Roberts edition, because, you know, Chief Justice Roberts is fond of saying the district court judges have a lot of sense and discipline, and they try to do equity. And in any event, it was nice to see the opinion not only fully embrace the purposes of the statute and knock down efforts to undermine it, but also knock down some of these other arguments that have been made over the years. As to where we're going to go now, as the courts begin to wrestle with what, the difference is amongst and between proximate causation and functional equivalence and, foreseeability, we shall see. But I have to tell you that my early soundings of some of the environmental attorneys who are water lawyers is that they're feeling as if these prior tests, this new test, gives them some room to make some arguments that will hopefully help them continue to protect the waters of the US. And with that, unless Shannon and Michelle have other things to say, I think we're open to questions.
I'm just going to come back on real quick here. We do have a few questions, and again, if anybody else has anything else that they want to ask, please send it to me via the chat. Michelle, let's start with you. This first question is from Kathy Robb. She asks, how will the Maui decision, which requires permits for some groundwater discharges, be reconciled with the final Waters of the US rule published last week, which excludes groundwater entirely from the definition of the waters of the US?
Sorry, I had muted myself. That's I think that those two things can be reconciled here, in that what the Supreme Court has done is not say that discharges to groundwater will be in all instances regulated. What they're saying is that one cannot discharge into groundwater with the knowledge that it's going to reach navigable waters of the United States, as a means of evading those permitting requirements. You can't use that intermediary medium of groundwater, just like you can't use the intermediary medium of land or air to evade the requirements of the Act. So if you have groundwater that is not, doesn't have a direct link to surface waters, or that groundwater may ultimately mix with surface waters, but does so at a significant distance away or over a period of many years, that's not going to be subject to regulation here. So I think that there's a very easy way to reconcile those two things. We're not talking about requiring permits for all discharges to groundwater. We're looking at it through this lens of these other factors.
Thank you, Michelle. We have another question here. This one is from Angela Hessenus. And Angela, I apologize if I mispronounced your last name there. Steve, I'm going to throw this one to you. What happens now after the Supreme Court's decision to those cases you mentioned that were previously decided in other circuit courts with a different outcome? Will those cases get revisited?
That's a good question, Angela. Everybody's expecting now that these other cases, to the extent they were pending on the Supreme Court docket, will be sent back now in light of this ruling, but nobody knows for sure, unless Shannon and Michelle have seen something on the Supreme Court docket that I've missed in the last 3 days. The assumption is, first of all, that this case itself, the Maui case, of course, got remanded in the Ninth Circuit, and I was just talking with the Earth Justice lawyers yesterday, and there are a couple things could happen there. The Ninth Circuit could take this opinion from the Supreme Court, and the Ninth Circuit could itself say, well, we've already basically found this discharge to be the functional equivalent of a direct discharge, and therefore the county loses, and that could end it. Or the Ninth Circuit could punt it back down to the district court, where, by the way, there was lots of evidence that there was a direct link. As Michelle and Shannon mentioned, they ran a tracer dye test, and there's no question this is the functional equivalent of a discharge. But eventually, after maybe a few more legal fees are run up, everybody expects in the Maui case that the County of Maui is going to have to get a permit. As for the other cases, people, again, are expecting those cases to also go back down for proceedings that will hopefully take account of this new test that Justice Breyer has formulated. And we'll see how they go.
Thank you, Steve, for the answer. We've got another question here. This one is from Jeff Thaler, and Shannon, I'll throw this one to you. Did the speakers brief the standard of review issues that had been talked about post-decision, excuse me, as to Chevron versus Chevron waiver and type of deference for interpreting statutory language?
So interestingly, the opinion really didn't focus on statutory interpretation. Our brief certainly did. We went into that quite a bit on the proper way to interpret the words within a statute, given the context and their plain meaning. I'm going to look to Michelle and Steve for nods. I don't recall Chevron deference being a primary factor at the point at which it reached the Supreme Court. I imagine someone threw in Chevron deference back at the district court level.
Could I just jump in, Michelle? We specifically took on the deference point to the extent that we said, you got to be kidding us if you want to get deference to this interpretation. EPA, just to refresh everybody's recollection, EPA for about 40 years had interpreted the statute to mean that you could, in fact, require a permit if the discharge went through groundwater and connected to surface water. And then literally after the Ninth Circuit had decided the case, the new administration reversed that interpretation and said, no, basically, if the discharge so much as touches groundwater, you're magically okay. That, by the way, if I could just say, that I think may have been the point where Justice Roberts decided that was a bridge too far. I know during the oral argument, he specifically asked counsel for the County of Maui something like, let me be clear, counsel, are you saying that if the pollutant so much as touch groundwater, there's no way that this permit applies? And Councilman Howard said, that's correct. And I thought I saw Roberts literally frown and make a little note on his notebook, but be that as it may, after 40 years of one interpretation, EPA switched gears. And so our view was, well, first of all, that is not entitled to any kind of deference, not Chevron deference, not Meade deference, not Skidmore deference. And in fact, interestingly, at the oral argument, Sister General didn't even ask for deference. He just said, EPA's interpretation is X and you should follow it. He never really used the phrase defer to these guys because it was so clear, I think, that would have been met with some hostile fire from the bench. And so it was kind of quaint to watch Breyer discuss it briefly in the opinion where he said, under this doctrine, the court sometimes refers to as Chevron deference, we're not going there. We often listen to what an agency has to say, but in this case, their interpretation is just unreasonable. We're not going there, basically.
Jeremy, you're muted.
Sorry about that. I was trying to, I appreciate that. Thank you, Steve and Shannon, I appreciate it. We got another question here from Robin Craig. This one says, one of the issues that has surrounded waters of the United States is that opponents of coverage conflate waters of the United States with other elements like point source. For example, lots of controversy over ditches as waters of the United States, while ignoring that they can still be point sources, or conversely assuming that a finding that there is a water of the US ensures CWA jurisdiction when it does not. In your opinions, and Michelle, I'll start with you on this one, did the Maui County Court evidence an understanding that there are multiple jurisdictional elements?
Yeah, they didn't really focus on those jurisdictional elements. I think that it was, just reading between the lines of the case, it's clear that they were not buying the conflation of, say, groundwater with point source, groundwater with non-point source. There was a significant concern about, trying to differentiate between the point sources and non-point sources, but then understanding that groundwater is a separate medium entirely, just like land is a separate medium. And so I think that the court was very clear about those elements. But in terms of other jurisdictional elements, they didn't really seem to get into a discussion of that or fret about that. It seemed, that they really understood that you had these types of things that were point sources. They could be natural features, such as ditches, but they were distinct from the waters of the United States themselves. So I don't think that they really got into that very much, but I'll defer to Shannon and Steve to see if there are some contrary opinions there.
Thanks, Robin, for that question. And I would just say Robin's one of the professors who signed on to our brief, so thank you for that. And we have Professor Agard on the line too, I think, who signed the brief, and maybe others. Robin, we could talk a lot about this, I think, but we won't today. But one of the things that struck me in rereading all this is I was remembering Kennedy's opinion in Rapanos that talked about setting up a significant nexus test for defining, the scope of the waters of the U.S. And now we have significant nexus, and now we have functional equivalent, which I think presumes some sort of nexus. So I think there's a lot of room for law review articles and further discussions, what I would say. But I don't think Justice Breyer made any of this whole jurisdiction, scope, and reach thing much clearer in his opinion. I don't think that was his purpose.
Thank you, Michelle and Steve. I'm looking through the chat. I don't think that we have any more questions. If just while I'm talking here, if anybody else has anything that they want to ask, please feel free to send it. One of my colleagues, Claire Herman, is going to post a link in the chat shortly. I think I just saw it come up with some extra information if anybody else is interested. And seeing no questions, no more questions. I just want to say, Michelle, Steve, and Shannon, thank you very much for doing this today. Really appreciate all the information. And thanks to all of you for joining. We'll have the video up on YouTube as soon as possible so that you can take a look. And we appreciate all your time today.
Thank you, everybody, for joining us. Hope you're all well. Stay
Thanks,
safe.
everybody. Thank you.
Thank you.